Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on human rights and duties, a constitutional law perspective, on behalf of the content writer Dr. K. Sita Manikayam, assistant professor Dr. B. R. Ambedkar Law College, Andhra University. This unit will aim to fulfill certain learning objectives which include the following. Number 1, understanding how the Constitution of India incorporates international human rights principles. Number 2, understanding how the provisions of the Constitution under parts 3 and 4 can be related with the provisions of the Universal Declaration of Human Rights. Number 3, learning about the role of Indian judiciary in protecting human rights. With the above learning objectives, friends, let us start this unit on human rights and duties. Our discussion mainly takes account of the constitutional law perspective. The Universal Declaration of Human Rights, established by the General Assembly through its resolution passed on 10th December 1948, constituted a significant event in the birth of human rights at international level, and therefore constitutes a document of enormous relevance for the human rights jurisprudence. It was also an encouragement for all the states to value certain identifiable and basic rights of the people within a state. The rights incorporated in Universal Declaration of Human Rights, which are further expanded by the other two covenants, International Covenant on Civil and Political Rights, also known as ICCPR 1966, and International Covenant on Economic, Social and Cultural Rights, also known as ICESCR 1966, are legally binding on all those states which are parties to the treaties. Together, these three international instruments, Universal Declaration of Human Rights, ICCPR and ICSCR, constitute the International Bill of Rights. It is interesting to note that the framing of the Constitution was being done at the time when Universal Declaration of Human Rights came into existence. The Constitution framers therefore could not afford to be oblivious of the fact and gave due relevance to these emerging international standards. The principles contained in UDHR can be seen to be adopted in the form of fundamental rights and fundamental duties under the Indian Constitution. It is generally observed that the civil and political rights are protected under Part 3 of the Constitution, whereas the economic, social and cultural rights have been incorporated under Part 4 of the Constitution. The fact that Part 3, which is fundamental rights, is made enforceable, while Part 4, which is director principles of state policy, is not enforceable, might sound like a deviation from international standards. However, that is not the case. Even internationally, the civil and political rights are seen as possessing the characteristic of immediate enforceability, while the economic, social and cultural rights are deemed to acquire progressive realization through the hands of the state. This distinction between legal claims under ICCPR and realizable interests under ICESCR seemed to suggest an inherent hierarchy within human rights. However, this debate has now been settled in favor of universality and non-fragmentability of human rights. However, friends, we need to understand that international law does not become a part of Indian law unless incorporated by the parliamentary legislation. Therefore, the application of international human rights norms in national jurisdiction is dependent on incorporation of these norms in municipal system. Where such human rights have been incorporated into Indian law, the courts have no difficulty in enforcing them. For example, the Protection of Human Rights Act 1993 gives recognition to the rights of life, liberty, equality, and dignity of an individual embodied in the international covenants. India is a party to conventions on elimination of all forms of racial discrimination 1966, suppression and punishment of the crime of apartheid 1973, prevention and punishment of the crime of genocide 1948, elimination of all forms of discrimination against women 1979, and Child Rights Convention 1989, among others. Coming back to the Indian Constitution, friends, it would therefore not mean that non-enforceability of Part 4 of the Constitution stands as an indication of the malified intention upon the state. The makers of the Constitution included the fundamental rights in the Constitution because they were considered essential for the development of the personality of human being and to preserve the dignity both individually and collectively. The writers of the Constitution regarded democracy of no avail if civil liberties like freedom of speech and religion were not recognized and protected by the state. For them, it seemed democracy meant a government by opinion, and therefore the means of formulating public opinion was secured for the people of the country. It is because of this reason that the Constitution guaranteed to all the citizens of India the freedom of speech and expression alongside other equally relevant fundamental rights. The fundamental rights in Part 3 of the Constitution have been guaranteed under the 7 broad categories, which are: number 1, right to equality, Articles 14 to 18, right to freedom, Article 19 to 22, right to education, Article 21A, right against exploitation, Article 23 and 24, right to freedom of religion, Article 25 to 28, cultural and educational rights, Article 29 and 30, right to constitutional remedies, Article 32. It is interesting to note that the Constitution, 42nd Amendment Act 1976, inserted Article 51A as Part 4A, providing for fundamental duties of every citizen. This seems to be in consonance with Article 29(1) of UDHR, which says, everyone has duties to the community in which alone the free and full development of his personality is possible. It is, however, surprising to note that until 1976, no provision was made for duties, even though the traditions and temper of Indian society had always laid much emphasis on duties throughout the ages. Article 51A of the Constitution reads, it shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. The states ask a parent or a guardian to provide opportunities for the education of his child. A ward between the age of 6 and 14 years has to get this benefit. Though Article 51A enlists the above mentioned 11 duties, there is no provision in the Constitution for direct enforcement of any of these duties and no sanction to prevent their violation. Although the fundamental duties were inserted during the emergency and very noble in the literal sense, cannot neither be part of a constitution or a statute nor give any locus standi. They cannot be enforced by a court but only by constitutional methods. The fundamental duties can be promoted by constitutional means and can be enforced by constitutional methods. Constitutional enactment of fundamental duties, if it must have any meaning, need to be used by the court as a tool to keep a check on state action drifting away from constitutional values. The fundamental duties enjoined on citizens under Article 51A should also guide the legislative and executive actions of elected or non-elected institutions and organizations of the citizens, including the municipal bodies. As the Verma Committee on Fundamental Duties noted, essentially all that is concerned in the fundamental duties is just a codification of tasks integral to the Indian way of life. A close scrutiny of the clauses of Article 51A indicate that a number of these clauses basically refer to such values as have been a part of the Indian tradition, mythology, religion, and practices. Judiciary in every country has an obligation and constitutional role to protect basic human rights and fundamental freedoms. As per the mandate of the Constitution of India, this function is assigned to the superior judiciary, namely the Supreme Court of India and the High Courts. The Indian judiciary has, without doubt, adopted innovative approaches, developed new tools, and invented new remedies to deal with increasing challenges to the basic human rights from the government as well as from the centers of power. The judiciary in India on almost every occasion has endorsed basic human rights through its verdicts and resolved that the state should expand its welfare policies to benefit the people. Friends, let us now discuss the major contribution of judiciary in accepting human duties, and then we will subsequently discuss the role of judiciary in acknowledging the human rights. In Ames Students' Union versus Ames, a 3-judge bench of the Supreme Court made it clear that fundamental duties, though not enforceable by a writ of the court, provide valuable guidance and aid to interpretation and resolution of constitutional and legal issues. In L.K. Kulwal versus State of Rajasthan, the court held Article 51A as the duty of the citizens However, Article 51A gives a right to the citizens to move the court for the enforcement of the duty cast on the state instrumentalities, agencies, departments, local bodies, and statutory authorities created under the law of the state. The court on similar occasion also stated that the collective duties of the citizens imply the duty of the state. Let us now move ahead and understand the judicial approach in accepting human rights. The Indian judiciary, with its widest interpretation in the observance of human rights, has contributed to the progress of the nation and to the goal of creating India as a vibrant state. For instance, in Srimati Neelabati Behera and Lalita Behera versus State of Orissa and others, the Supreme Court asserted the jurisdiction of the judiciary as protector of civil liberties under the obligation to repair damage caused by officers of the state to fundamental rights of the citizens. It held that the state is responsible to pay compensation to the near and dear ones of a person who has been deprived of life by their wrongful action. The court did this by reading into Article 21, the duty of care, which could not be denied to anyone. For the purpose, the court referred to Article 9, Clause 5 of the International Covenant on Civil and Political Rights, 1966, which lays down that anyone who has been the victim of unlawful arrest or detention shall have an enforceable right to compensation. Similarly, in Visakha and others versus State of Rajasthan and others, the Supreme Court said that gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. The common minimum requirement of this right has achieved global acceptance. In the absence of domestic law occupying the field, to formulate effective measures to check the evil of sexual harassment of working women at all workplaces, the contents of international conventions and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity under Articles 14, 15, 19(1)(g) and 21 of the Constitution, and the safeguards against sexual harassment implicit therein, and for the formulation of guidelines to achieve this purpose. In the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly, guidelines and norms are hereby laid down for strict observance at all workplaces or the institutions until a legislation is enacted for the purpose. This is therefore one example where court actually laid down a standard. This is done in exercise of the power available under Article 32 for the enforcement of the fundamental rights, and it is further emphasized that this would be treated as the law declared by the Supreme Court under Article 141 of the Constitution. Further, in Apparel Export Promotion Council versus A.K. Chopra, a two-judge bench of the Supreme Court yet again dealt with a case of sexual harassment of a lady secretary by her male superior. The court relied on the Convention on Elimination of All Forms of Discrimination Against Women, 1979, and other international instruments on human rights. This approach was once more evidenced in Chairman Railway Board versus Chandrima Das, In this case, a woman tourist of Bangladesh was raped in the railway guest house by the employees of the railway board. The petition on her behalf was filed by an advocate of Calcutta High Court. The Supreme Court apprehended that our Constitution in Part 3 guarantees all the basic and fundamental human rights set out in the Universal Declaration of Human Rights, 1948, to its people and other personnel, which includes aliens, and that it will be appropriate for the court to refer to international human rights norms while interpreting the national constitution. In Guruvayur, there was some managing committee versus C.K. Rajan. The court held that it will not hesitate to invoke international conventions on human rights to protect group rights of people. It is not only the first generation and the second generation human rights which have been accepted and applied by the Indian court, but the third generation or solidarity rights have also been recognized in India. In N.D. Jayal versus Union of India, a 3-judge bench of the Supreme Court accepted the right to development as an integral part of human right. The Constitution of India also does not expressly provide for the right to privacy, but the Indian judiciary has traced this right in Article 21 of the Constitution. In District Registrar and Collector Hyderabad versus Canara Bank, the Supreme Court invoked Article 12 of the UDHR and Article 17 of the Civil and Political Rights Convention 1966 in upholding the right to privacy. The Indian Supreme Court has followed 2 lines of reading in support of applying international human rights norms in its domestic jurisdiction. Firstly, the fundamental rights which are guaranteed by the Constitution can be interpreted in the light of international human rights norms, since these norms indicate the current accepted view of the content of the various fundamental rights that are contained in Part 3 of the Constitution. Secondly, the court has also said that international covenants declaring universal fundamental rights can be used by the courts as a legitimate guide in developing common law. In conclusion, friends, we can therefore say that the Constitution prescribes confident fundamental rights and fundamental duties which are in line with the principles of international human rights standards. Fundamental rights have been time and again interpreted and upheld by the Supreme Court of India. And the court has even relied on international human rights instruments to protect the fundamental rights of the people, and has in some cases even tried to interpret the collective fundamental duty of the society as the duty of the state. With this, we come to an end of this unit. I thank you very much for listening with patience.